Hello, I'm Meetali Singh and I'm currently working as a legal intern at LEXIS and Company. Today in this video, I will be continuing the topic which I started in my previous video, that is the nature of the Indian Constitution. So we have discussed the federal characteristics of the Indian Constitution. Now in this video, I will be discussing provisions of the Constitution not supporting the federal principle and what is the conclusion, what exactly the nature of the Indian Constitution is. So I will continue this concept in this video. We will start with the Union of States. Article 1 of the Indian Constitution states that is Bharat shall be a union of states. It is to be examined here whether the use of word union was intentional or not, because the word federation has nowhere mentioned in the Indian Constitution. It was there in the draft of the Constitution, but it was later removed by the makers of the Indian Constitution. And it was, however, a purposeful omission on the part of the drafting committee. Its chairman, Dr. B.R. Ambedkar, justified this removal by mentioning in the addition of the word federation was added after the ratification. Now, the second feature of Indian Constitution which does not support the federal principle is the appointment of governors. Appointment of governors of various states is done by the central government. Governor is the constitutional head of the state. Simultaneously, he is also the representative of the center. The center government under Article 355 has to ensure that there is no failure of constitutional machinery in the state and the states are protected from internal and external disturbances. So, to carry out that mandate, the central government has the authority under Article 356 of the Indian Constitution to impose President's rule in the state, and it is the duty of the governor who has to inform the center about the failure of the constitutional machinery of the state. Therefore, this power to appoint the governors that would be the head of the respective state is an essential unitary feature of the Indian Constitution, and it does not support the federal principle. Now, the next feature which does not support the federal principle is the single citizenship. Here in India, we have a concept of single citizenship. The citizens will have only one citizenship, that is the citizenship of India. States की citizenship नहीं होगी, आपके पास बस India की citizenship होगी. It does not matter whether you belong to Delhi or Mumbai or anywhere. You would only have a citizenship of India. So, the Constitution of India has proposed a single citizenship for the whole country. In a federal country like the United States of America, there is a dual citizenship. But in India, we have a single citizenship. So, it also opposes the federal principle, because in federalism, federal form of government has a concept of dual citizenship. Next point is the Parliament's power to legislate in the national interest. Under Article 249, Parliament is empowered to make laws with respect to every matter enumerated in the state list only if the Rajya Sabha passes the resolution by 2/3 majority that it is necessary for the national interest. So it is also not a feature of federalism. It is one of a feature of unitary form of government. Now the next feature is the unified judiciary. In India, we have centralized judiciary with the Supreme Court at the top position, as opposed to the federal system having a dual system of courts. The Supreme Court holds the apex position in our unitary judicial system. This feature is not supported by federalism. The next point which does not support the federal principle is emergency provisions. When the proclamation of an emergency takes place, the division of power between the center and the state takes a vital change. All the power comes in the hand of the center. Under Article 356 of the Indian Constitution, if the President deems right that the condition of governance of the state can't take place according to the principles of the Constitution, then the President can dissolve the legislature and other state machinery, and he can himself assume that all the state functions are in the hand of center or President. So now we'll jump on to the conclusion. So the Indian Constitution empowers the center to interfere in the state matter and thus places the state in the subordinate position which violates the federal principles. Therefore, Indian constitution is neither purely federal nor purely unitary, but it is a combination of both federal and unitary, so we can call it a quasi-federal constitution. So thank you, that's it for this video, and I will see you in my next video. Till then, do subscribe to the channel for daily updates.